Okay, good evening, everybody. Are you recording now?
Cecília, só uma coisa importante. 8h30, sessão solene lá.
Okay,
Só para saber.
so I will try. Good evening. We are going to start the panel, and this is the panel titled Law, Human Rights and Social Exclusion. I'm Cecilia, Santos, MacDowell, Santos, and the speakers here on my side, Roberta de Simini,
Giacomo Pailli, Firenze. And Alessandro Simoni from Firenze as well.
Pablo Holmes, Universidade de Brasilia, UNB.
We will speak each about 20, no more than 25 minutes, and try to leave some time for discussion. So welcome to our panel. And we will follow the order that you can see in the program.
Which is?
The order of the names, yeah?
Yeah.
For the presentations, okay? So that's why I'm first. It's easier. So let me just calm down here, because I was coming from the other session. First of all, I am Brazilian, but I'm speaking in English because I was asked to speak in English, and so that's not a problem, but just to explain why. And I wanted to thank the organizers of the Congress, for especially Fernando Rister de Souza Lima and Celso Campilongo, for inviting me to participate and to be part of this panel. It is a great pleasure for me to be here because I did my master in law at this school, and I was advised by Professor José Eduardo Faria. So that's why this is special for me. It's also my first time participating this in the Congress of the Brazilian Studies of the Association of Sociologists of Law in Brazil. The title of the panel is very broad: Law, Human Rights, and Social Exclusion. But I believe each of us will have a more focused presentation, and mine is titled, Can Human Rights Mobilization be Post-Abyssal? Human Rights Law and Exclusion in the Light of the Epistemologies of the South. I want to start my brief remarks dedicating this talk to Marielle Franco, who was a city council member from Rio de Janeiro. You probably know that, but maybe some of you don't. And she and her driver, Anderson Gomes, were brutally killed this year in the evening of March 14th, right after Marielle had left an event she had organized on young black women changing power structures. Marielle was a black bisexual woman from the poor and marginalized Maré community, a defender of black and women's rights, LGBT rights, fighting against police violence and human rights violations of favela residents, while also defending the human rights of police officers killed in the so-called war on drugs undertaken by the Brazilian government. A few days before her murder, Marielle Franco was appointed rapporteur of the Parliamentary Commission on Human Rights to monitor the military intervention that since February 16th has prevailed in Rio. This intervention has granted the military the power to arrest and kill any suspect, quote unquote, of drug dealing in the shanty towns of Rio, suspending constitutional and fundamental rights. On February 28th, Marielle Franco published on her Facebook profile, quote, "We take a stand and are against this intervention. It is a farce with electoral objectives. We will occupy this space," the commission, and state power, fulfilling our oversight role as a municipal legislator, end quote. One day before she was murdered, she protested on her Twitter account, quote, "Another murder of a young man at the hands of the military police. Mateus Melo was leaving church. How many more will need to die for this war to end?" End quote. The military intervention in Rio has been the toughest measure of Michel Temer's government in the election year of 2018. It's clear that Marielle Franco's death was a political crime, with the goal of silencing and instilling fear in those trying to denounce the necropolitics of gender, race, and class carried out by police forces and/or militias. The military intervention only escalates this violent situation. Unfortunately, it's not the first assassination of a radical human rights leader from marginalized communities fighting against racial, class, and gender and environmental inequalities and injustice in Brazil and in the Americas. Like in the case of Chico Mendes and Berta Cáceres, just to cite a few, the assassination of Marielle Franco immediately sparked a national and international wave of protests and vigils in her honor. Since March 2018, Maré community leaders, Marielle's family members, human rights organizations such as Amnesty International in Brazil, Black women's organizations, and diverse social movement actors have been mobilizing and fighting for justice in the case of Marielle, and have continued their struggles against racism, heteropatriarchy, and neoliberal policies that further promote social exclusions. Yet 6 months have passed, and the investigation is still unfinished. Who killed Marielle? Just like who killed so many other leaders and racialized and gendered bodies from marginalized communities? This is the question that serves as the hashtag of Amnesty International campaign on the case of Marielle Franco. Can law and human rights mobilization provide an answer to this question? Even if justice in this particular case is achieved, can human rights mobilization help to end abyssal exclusions, such as the exclusions facing marginalized communities in Brazil and elsewhere? What should be the tasks of a critical, non-colonizing sociology of human rights, law, and justice? I have spent a decade studying transnational legal activism for human rights and case against the Brazilian state presented to the Inter-American System of Human Rights, specifically the Commission. In this talk, I draw on this research to briefly reflect on human rights mobilization in the light of the epistemologies of the South, formulated originally by Boaventura de Souza Santos. I'm a member of a research project coordinated by Boaventura Santos at the University of Coimbra, where I am also a research member of the Center for Social Studies. I should start saying that the South here is understood not in geographical terms, but in epistemological terms, and it refers to the marginalized communities, both in the global North and the global South. From the perspective of the epistemologies of the South, there are two types of exclusion: abyssal and non-abyssal. The first refers to the exclusions based on colonial, patriarchal, and capitalist relations that render the excluded, racialized, and gendered bodies as non-human. Their subjectivities, their knowledge are made invisible or silenced, including by law and modern law and colonial law. Marginalized communities in their struggles for dignity are subject to constant violation and appropriation. For example, violence and exclusions facing Maré residents, exclusion and assassination facing indigenous communities, feminicide, killing of transgendered people, and so on. The non-abyssal exclusions, on the other hand, relate to the tensions between regulation and emancipation. In other words, the modern law, also in the former colonies. For example, workers' rights in a factory and labor movements, or using the Constitution to fight to have the right to health and funded by the state. This approach to the two modes of sociability and social exclusion builds on post-colonial theory and Fanon, of course. Quijano's work is illuminating in addressing the constitution of the other, the racialized, non-human, non-modern racialized bodies. Race and racism are crucial in the production of a white European identity and Eurocentric knowledge production, including Eurocentric knowledge production of human rights, both in the colonies or post-colonial societies and in the center, in the core. The coloniality of power refers precisely both to the racial division of labor in a world system and the silencing of other forms of knowledge and existence. In order to explain how, in my reading of the epistemologies of the South, human rights mobilization might be approached, let me first map what I see as the current terrain of human rights politics in Brazil. And I'm using Brazil as a case study. And Brazil can be perhaps representative of other parts of the world. I have identified 4 types of politics of human rights in the past 15 years in Brazil. First, a liberal and perspective on human rights. Historically, this has been the hegemonic approach to human rights, centering on state law and privileging the individual rights, approaching non-abyssal exclusions and violations as exceptions, not as constitutive of law, the state, and the societies. Human rights from above, neoliberal politics with legal recognition of human rights. This is the minimalist inclusion perspective on liberal law and democracy. The liberal politics on human rights can be illustrated by both Cardoso and Lula administrations in Brazil, even if Lula created more opportunities for the inclusion of new subjects of rights. Another perspective is human rights as a farce. It used the liberal approach as an image to justify the state of exception. For example, Temer and Rede Globo depoliticized the death of Marielle Franco, just to continue with the same example and also honoring her legacy, to defend more military intervention in the name of the war on drugs. Hidden interests of state actors and private interest groups that can benefit from both the liberal and a more reactionary or even a perspective against human rights. And that's the third position. A reactionary, far-right, fascist politics on human rights and against human rights. Jair Bolsonaro was the only candidate in the 2018 presidential elections in Brazil who did not make any comments on the killing of Marielle Franco. This politician and his followers view human rights as culprits. They don't see as human racialized bodies from marginalized communities, women, the LGBT people, human rights defenders, and so on. Extermination of the other is this kind of politics. A reactionary movement against human rights have been creating, for example, fake news on Marielle Franco on social media, just to give again, follow the same story. Reactionary politics of human rights has also appropriated the language of human rights against human rights, using freedom of expression and equality. It's not so new. It's a movement that can be dating back to the 1990s with this invention of an ideology of gender, and conservative sectors of both the Catholic and evangelical church are promoting this movement. And in this case, the reactionary politics of human rights can be legitimized by a liberal perspective on human rights as well. So they are not completely separated. Then I see a critical, post-colonial, and intersectional perspectives on human rights. These perspectives focus on the limits of the liberal legal framework on human rights to address both the abyssal and non-abyssal exclusions. The post-colonial or decolonial perspective focuses on the complicity of the states and human rights law as part of a colonial, imperial, and neoliberal project of development and globalization that promotes abyssal exclusions. The intersectional perspective also focuses on the abyssal exclusions and colonial practice of human rights from both individual and structural standpoints. The main questions they will ask: who is human? What counts as human rights? Can human rights law challenge the dominant structures, inequalities, and discrimination against the poor, blacks, LGBT women, and indigenous peoples in the Americas? How can human rights law be used against states that historically have inflicted violence on racialized peoples and First Nations in the Americas? Of course, they include a very diverse field of movements, grassroots organizations, and communities of struggles. And in very general terms, we can see two different groups: struggles over collective rights, primarily, centering on land and territories, the existence, integrity, self-determination, autonomy of a people like the indigenous and quilombolas, the rural workers, and then the struggles over the existence, integrity, and autonomy of individual bodies, and here the urban LGBT, feminist, black women's, and black rights movements. Is it possible to mobilize human rights against reactionary and politics of human rights and abyssal exclusions? I approach human rights not only as law and norms, but also as values, ideas, knowledge, practice, talks. There are multiple conceptions of human rights produced both from above and below, both in the hegemonic legal and judicial institutions of the state or at interstate organizations, as well as in hegemonic parallel non-state organizations, and in the marginalized communities. Law and state law in its turn must be conceived not as a site of complex and contradictory discursive struggles. It constitutes and gives meanings to social categories and identities from which one may or may not claim rights. Legal mobilization may be one strategy to mobilize human rights for social inclusion and justice. As defined by Michael McCann, legal mobilization refers to the translation of a claim into the language of rights. It includes different types of legal practice, such as litigation, legal campaigns for new laws, mobilizing for legal implementation, legal education, raising rights consciousness. It can be defensive or offensive. However, from the perspective of the epistemologies of the South, legal mobilization for human rights, I think, must be reconceptualized in two ways. First, a pause-abyssal mobilization for human rights must go beyond an individualistic and legalistic approach to human rights. Boaventura de Souza Santos addressed this question in his famous article, Can Law Be Emancipatory? Also in the book, Law and Globalization from Below. Subaltern cosmopolitan legality, as he and Cesar Rodrigues Garavito call, implies that state law is not the only source of legality and illegality. It also means that human rights mobilization may be legal, illegal, or illegal. It must privilege collective rights, although individual rights are not abundant. The struggles must be politicized before they are legalized. That is, they must combine social and political mobilization. And they must be trans-escalar, including the articulations of local, national, and transnational mobilization. and they must challenge systems of domination and subordination, such as capitalism, colonialism, racism, heteropatriarchy, etc. Secondly, a post-abyssal politics of human rights would also involve a politics of the knowledge production of human rights, and this is the novelty with the epistemologies of the South. The epistemologies of the South focus on knowledge and practice born in struggles carried out by oppressed communities. And this is very important to distinguish from legal mobilization that focus on violations rather than struggles. And violations defined from the perspective of the law. So here it's a different starting point to think about human rights mobilization. The scientific, the epistemologies of this, the ecologies of knowledge, that's another expression in the epistemologies of the South framework, refer primarily to such knowledge, the knowledge of the oppressed communities. But scientific and legal knowledge and modern law can also be part of the ecologies of the knowledge, ecologies of knowledge, insofar as they contribute to the struggles of oppressed communities and individuals. Yet the objective of human rights mobilization must go beyond the paradox of human rights as both a symbolic and or normative force, as discussed by Marcelo Neves, for example, in a very interesting article about the symbolic force of human rights. Gurminder Bambra's framework of human rights knowledge production offers a guideline to the study and practice of human rights that is in line with the epistemologies of the South. From this perspective, the task of scholars, social legal scholars, and human rights advocates would center on three interrelated analytical and normative concerns. First, to analyze what she's using a framework of silence, which is not necessarily lack of voice or speech, but what's silenced, what's included and included in texts, in practice, in talks. So to analyze the silence that renders certain social categories or meanings and identities excluded and others included. So that's the exclusion inclusion. To expose the act of silencing, for example, in a legal decision, in the text of the law, that reproduce a hierarchy of political power through the construction of meanings and identities in the moment of representation. And that includes also human rights NGOs. And finally, to reflect consistently and carefully on the responsibility of the intellectual and human rights advocates to undermine this act of exclusion inclusion by problematizing the resulting silence. Applying this perspective to human rights mobilization, legal knowledge and practice on human rights must be used to serve human rights mobilization born in struggles. And this knowledge must be exchanged in a horizontal, non-colonized, non-extractivist manner. Intercultural, including interlegal and inter-human rights translation, is the means through which this different knowledge can be exchanged in or could, ideally, in non-extractivist ways. Human rights NGOs, and I have only 1 minute now, that embrace a liberal politics on human rights have used international human rights law to promote the rights of oppressed communities. NGOs and social movement actors with a critical and post-colonial approach to law and the state have also used human rights law. In the case of my research, black rights organizations, black women's rights NGOs in Brazil, for example. Oppressed communities have both rejected and used human rights law, depending on the context and their needs. In other words, human rights law and the language of human rights have been appropriated by different struggles, wherever this is possible and convenient. There have been some emblematic cases that I have closely examined in my research in the case of Brazil and the Inter-American Commission. However, this use of law is mostly defensive, And it's very much controlled by professionalized human rights NGOs, which may, even if they intend to represent the marginalized communities, may silence or make invisible the knowledge, the practice of the communities they are pretending to represent. So to conclude, currently there are very little political opportunities to mobilize human rights from within the state, even from a liberal perspective. Post-abyssal politics of human rights is likely to face execution of community leaders, as it has always been the case, and human rights defenders, as was the case of Marielle Franco. Law is not the only language of human rights, but it is important to mobilize international human rights institutions, to go beyond liberal law, and to confront reactionary politics of human rights at the local and national level. But I'm not here praising international human rights law necessarily, because that is not separated from the states. The liberal human rights NGOs, as I said, can serve as political allies, and they are very important. But they often make invisible or silence the knowledge born in struggles. So what's needed? To listen, to work with, not to work for the communities, if that is what they are trying to promote, a progressive non-abyssal politics of human rights. A post-colonial and intersectional approach to human rights is necessary. However, the challenge is how to exchange knowledge on diverse struggles that sometimes are contradictory and silencing of one another also. But I will not elaborate on this, and we can discuss later. Thank you. Now we are going to Alessandro Simoni, yes, from the University of Florence.
So you will speak last, or because we have to speak now also? Maybe better you speak first.
No, I mean,
You can just speak you must speak about this basically the same topic in different sections.
okay, I can speak last. There's no problem.
So you speak last.
Yes.
No, it's okay.
Yeah, I speak last.
Okay.
Yeah, you can. You want to go here?
Giacomo.
Sì. It just happened. Pedro.
Faccio.
20 minutos. Queriam falar de uma hora no final. Queriam falar os três. Tá?
Of course.
I knew it would be boring, but it's okay. Don't worry.
Você quer? Certo.
Little bit careful, okay?
Deixa eu... Sem problemas.
So this picture, it's say, as you, I don't know to what extent you are following Italian politics, but in any case, the one on the left is the current Prime Minister, and the one on the right is the Minister of Interior. The name of the Prime Minister is Giuseppe Conte, the other one is Matteo Salvini. Why names are relevant? Because you see, they keep in their hands a sheet of paper with written Decreto Salvini, meaning Salvini decree, meaning a decree with the name of the person on the right side, the Minister of Interior. Under the name is Sicurezza e Immigrazione, means simply security and immigration, and then in the usual sign. Okay, why this is relevant and useful as a starting point for a discussion? Because here you're seeing a bit in a nutshell, let's say, the substance, the core of current Italian politics and the policy approach that is followed by the brand new government. Okay. here we are still in a phase, let's say, of everyone is trying to understand, because the new development has no, let's say, clear precedent in the Italian political tradition. The old lines do not any longer apply, and so on. So there was an anthropologist, D'Andrade, say to stay in the middle of the avalanche is not a better place to understand snow. So we are here on a daily basis trying to understand something which is moving very fast. But however, why this I think is a good starting point. First, the catchwords, migration, immigration, and security, the two challenges, but also the visual dimension. Since what you see, so it's relevant, and everything is conveyed in the media through short phrases, pictures, catchword, and slogan. You see, this is the key of politics, but this is happening in a scale which has not clear precedence in it. This way to present policies in the public arena, it's really even is interrelated with a transformation in the use of law as a tool to promote, to implement these policies. I will say more promote than implement, because here you are in a phase where nothing has yet really happened in terms of legal transformation. There are some kind of manifesto, discourse, which are launched. So it is interesting to see when these discourses will have to be transformed in actual policies and how they will transpose it in legal terms. As I will explain, we are starting from things that are not completely new. Since some of these tools were already used, were as I grown up in recent Italian history. But since this, let's say, this pioneering experience of previous government, of even left-wing governments, was a sort of laboratorium to this new way of, let's say, of trying to transform society through formally legal tools. The political discourse, which is based, the new government, say, launched this manifesto not with a traditional political program, but with a very detailed document called the Contratto di Governo, Contract of Government. It's a long document, things are vague, but however, you have some, let's say, refrains coming back regularly, where some key challenges are presented to the Italian society. Among these key challenges, the key problems, three are certainly some kind of pillars, so to say. One is migration control. One is control of urban marginality, with a special attention to Roma and Gypsies, who have a place in the context of government, and the relation with the Islamic community. You say nothing strange, because the migrant, the Roma, the Gypsies, and the Muslim are clear, let's say, dangers that you can sell on in the political market to get votes. In legal terms, what you can observe is we have a new, for instance, if you look at this new decree, the Salvini decree, certainly, particularly when it comes to migration, you have some, let's say, important things. But in any case, I don't think that the substance of the new legal instrument, where you really catch, where you can really perceive, say, the key, let's say, tool, the new approach in using law as a mean of social control. I think that the key point, as we will see, we divided our presentation in three sections, where Giacomo will speak more about how the control of urban marginality is implemented in practice and which legal tricks are behind it, while Roberta will speak about the relation with the Islamic community. If you look at the point of we will set aside migration policy as such, because this is not part of our work, and we will deal with migration only as part of a broader system to keep out of the public eye situation of social exclusion, meaning the status of illegal immigrant is more relevant not as a precondition for deportation, for a decrease of the number of migrants in the country, but more as, let's say, as a status which can simplify the keeping out of the public eye of persons who are perceived visually as a danger to the community. Our work, which is a work which started years ago in, let's say, completely different political conditions under left-wing government, and was a work that started focusing on the Roma. Roughly 10 years ago, Roma became, for a number of reasons, a central, let's say, topic in Italian politics. In the manifesto of the first, of the Berlusconi government, of the Berlusconi program, who then, let's say, brought to the victory of the right-wing government, for the first time, Roma, nomads, as were defined, appeared in a political program at the national level, not as on only a small local issue. Why this? Simply because the migration flow, let's say, following, not let's say, not as immediate causal link, but however, following after some years of the access of Romania in the European Union, brought to let's say, the moving to Italy of a group of Roma which were visually striking the eye, in a sense, were corresponding to the Roma stereotype. And this in urban centers in Italy, other citizens were confronted on a daily basis with a diversity which was perceived as dangerous for a number of reasons. This created, let's say, gave a political value to any effort, to any activity which could reach the result of moving this person out of the public eye, to go where doesn't matter. In order to do this, politicians, political actors of national and local level discovered that they have not let's use effective legal tools. Why? In old times, say, after in Italy in the last 50 years, the relation with Roma was also always a complex one, but the balance was reached in two ways. A part of the community had a status of illegal migrants, because normally there were persons coming from former Yugoslavia. So in order to get rid of them from the public eye, it was sufficient to ask a document. Do you have legal documents? Documents that make legal staying in Italy? Not. So, let's say, go away. The other tool was the criminal sanctions against begging. In Italy, until 1995, begging was a crime. Was no longer a crime after 1995, since after a decision of the Constitutional Court, which declared the crime of begging in violation of the Constitution, and a statutory act which took away the last provision, the last piece of the same article, criminalizing so-called disturbing begging. So after 1999, begging by adult person was legally not relevant. It's interesting that this happened in a time where begging was not perceived as a public problem. So it was even the last provision was deleted by an unanimous vote of the parliament. Immediately after, beggars became a topic of social debate, but the criminal sanction was not any longer, let's say, a tool to be used. Attention, this does not mean that begging was regularly prosecuted in Italy until 1999, not at all. was, let's say, a perfect example of selective persecution. Beggars were persecuted only when they became, let's say, their number or visibility was exceeding what was tolerable at the local level. The new beggars were Romanian citizens or EU citizens, so they could not even be removed by, say, raising their illegal migrant status. Which transformation in the legal, let's say, in the legal strategies all this implied? That the battle against urban marginality, the visible one, the Roma, became a purely local question with the use of, let's say, tools based on local regulation, nothing, let's say, directly related to criminal law. Was interesting, and so a lot of Italian municipalities tried to develop each one its own blend of, let's say, petty legal provision, let's say, a blend which was made only with the purpose, a means to an end, of, let's say, forcing this person out of the municipality. It's interesting that these strategies, and there were some municipalities which they built particularly effective strategies, they were presented as a models and followed by other one in, let's say, in a competition where sometimes the champions were left-wing municipalities, and Florence is an example. We will see how this, let's say, this has an implication, some theoretical implication, a very simple one, that these strategies completely bypass the ordinary, let's say, rule of law idea. So you mean there is a provision issued by some sovereign power, then there is the application of a sanction, and a court, let's say, which verifies whether the sanction is legally applied. The point is that these new strategies, as we will see, are based on a completely different view. Provisions are promulgated, even if they are sometimes blatantly illegal. So you issue a regulation knowing that it's in conflict with the imperative statutory provision, so they know it will never be legally enforced, but this doesn't matter. You build a provision just in order to give to the police or to the local police a tool to say to the person, go away, otherwise we will fine you. You see, okay, but what's the problem if and this sanction will never pass a judicial control? Because the strategy level is built in a way where the costs in terms of time, in terms of cultural and financial resources, of challenging in court the sanction of this illegal provision is largely exceeds what can be made by members of the target groups. All this, let's say, creates, and this is used in order to, let's say, to fight against the visibility of some urban marginals, but also to build deterrence against behavior like, let's say, prostitution, which are perceived for a number of reasons, let's say, something which must be kept out of the public eye. And this construction of, let's say, of a rule of law, this bypassing of the rule of law, making, let's say, rules that are just, let's say, scarecrows, so to say, as is, let's say, developing as a systemic approach, which creates some problems in order for even investigation, research. Because to understand, let's say, how pressure is made about marginal groups, you must go investigate law of sense based on traditionally insignificant provision, small administrative sanction, and where the impossibility to challenge is always often based on extremely technical tricks. This implies that to understand what happens, the key is action research. Action research, as we started an experiment in this perspective together with Giacomo in Florence, actually challenging some of these petty sanctions which were systematically issued against some beggars. Not an easy task, because first you must convince the targeted person, Romanian beggars, the clients, the clients, to give you a power of attorney. You must also follow some ethical rules in order to drive a battle which does not bring prejudice to your client, because your client, once you build a relation, they sign everything, any kind of papers, if they trust you. But you must be careful not to drive things too far. But it's a balance in any case. The other point is that paradoxically, the legal mobilization in this case does not need to be based on a very, let's say, progressive vision, on a very formalistic approach. We call it a conservative battle. So we always rhetorically use, let's say, arguments that say, you can be left-wing, you can be right-wing, doesn't matter. If you want to fight beggars, do it, but use legal tools. We always, it's more a joke than else, saying that we drive a legal battle with a conservative, right-minded approach, which is not very true. But it's interesting because it's to some extent you must see things from the other side, and that's a point. Often you cannot say forget. You're touching the hardcore of law, meaning that you know that law is, let's say, can be. And we say our vision is that the rule of law in this period of time is perverted and bent to, let's say, purposes and goals that are against, let's say, the idea of human dignity, because the regular use of any kind of legal tool in an extremely targeted and selective way to put pressure on specific kind of person which are perceived as, let's say, as a nuisance to society, in our idea is, let's say, is a violation of the core values of the rule of law. But in order to reach this result, you must, let's say, try and influence some nuts and bolts of the legal system, which often are not, let's say, part of the intellectual and research interest of person interested in human rights approach. This is, I'm saying, we will see how now we have a case which is pending in the Court of Human Rights in Strasbourg and one in the Italian Court of Cassation. If you read these cases, the files of this action, they are very boring documents, because we never raise the point of the ethnic identity or racial identity of this person, but just trying to present purely. I concluding that that things can change very fast. We say that we started with Roma because we're the ultimate example of, say, of groups which was perceived as different to be kept out, and so this selective use of legal tools was clearly targeted in a special group. And then meanwhile we have seen a transformation of the context where the begging by Roma is replaced by the begging from African refugees. which are equally perceived as a nuisance, but force a political actor to put it in a, let's say, different kind of discourse, because, let's say, in order this is a system where strategies are built with legal tools, but in a combination with stigmatization processes, often based on the use of local media, local newspaper. You see that you try to, often with simply visual, let's say, campaign, trying to present a specific group of person as a danger, immediately after giving legitimacy to this harassing campaign. I exhausted 1 minute. I tried to give you, let's say, a general picture of the problem, and now I switch to the real lawyer who will explain how things happen in practice. I have your slide, which I think I might say no. This is this was the first page.
No, questa è una immagine.
Okay, so this was not the slide. It was that to keep.
Or we can use Sophia's slides. Ma lei mi sente?
No, we have it.
All the slides you want.
No, okay.
No,
No. Okay, you can start speaking.
I know
while
my chicken. As
I
they
will
say. Let me- So, hello everybody. Thank you for being here, and thanks to Fernando, Chelsea, and all the wonderful organizers of this Congress. And just to begin with a disclaimer, I'm not a sociologist, so you will see that my approach, our approach, as Alessandro described, maybe suffers a little bit of sometimes a normative, too much a normative dimension, but we will see. So, as Alessandro said, it's a changing picture, so we are running behind a little bit what is changing, but still what we try to do is to ensure that there is at least a minimum respect of rules of the rule of law. And it's interesting to present the case of the city of Florence and the relation with beggars, because it is one of a very meaningful example of how the things that Alessandro explained on a general level went in practice. So, as you know, Florence is a tourist city with a strong tradition of left-wing government until now. We will see next elections, and so you could expect it to be open to social inclusion and to be more respectful of marginal groups, of marginal individuals. But as Alessandro hinted, in the last 10 to 15 years, it pays very well for politicians to, even from the left wing, to adopt a law and order approach. Law and order is what is required by the public. So we have to understand what I will say in a context in which the public is demanding this kind of strict approach. And so if a political force will put in their program that they want to give more rights to Roma groups or to beggars or to migrants, it is likely that it will not fare very well in the elections. So 1995 and 1999, begging as a crime disappeared from the Italian legal system. And it's not replaced at the national level with any provision that targets beggars or that allows the police to intervene because somebody is just begging. So it's not a right, but it's not even something that is prohibited. And if you take a liberal approach, if something is not prohibited, maybe you have freedom at least to do it. But this making a crime disappear from the book did not make the phenomenon disappear from the streets, from the society. And so after 2007, with a free movement from Romania, as Alessandro said, a lot of colorful individuals came into the streets of Florence begging and also engaging in other street-level economic activities such as cleaning the windshield traffic lights or cleaning the lights of cars just for €1 or so. And the mayor in that period it didn't have any legal basis in national law and in local law to act and to enable the police to do something about it. What he did, he issued an emergency ordinance targeting this kind of begging, so the cleaning of windshield at traffic lights and cleaning of lights at traffic lights. Now you have to understand that emergency ordinance issued by the mayor in Italy are an emergency power. The mayor in that case is acting as an agent of the government, so there is a different institutional settings, but they are meant to address issues like after a flood, after an earthquake, when there is, or maybe for sanitary reasons, when there is an outbreak of some disease. It's not really meant to address beggars at traffic lights. And certainly this was not something new also. So the use of this instrument was okay. The use of this instrument was clearly illegal. So it was clear that you could not use you could not use this kind of instruments. But what interested the mayor was not to have, as Alessandro said, to have something that was legally bulletproof, but just to give a basis, a legal basis for the police to act and to push beggars away from traffic lights. The provision also, it's not that easy to subject to judicial review of this emergency provision in a short period of time. So it takes a little bit of time. It was subject to judicial review, but what the mayor did was to replace the ordinance one after the other. Two things about this preliminary experiment by the city of Florence. The first was that this policy, although illegal, was effective. So basically, when you go around Florence now, you don't have this kind of activity anymore. They effectively managed to make this phenomenon disappear. And the second point that is interesting is that the first of these ordinances provided for criminal penalty in case of violation of the ordinance. So if somebody will go and clean the windshield at traffic light. But the Attorney General for the city of Florence decided not to prosecute any of those. He said that the mayor could not make reference to a certain criminal provision in the criminal code because it would amount to restore the crime of begging that was declared unconstitutional by the Constitutional Court and then abrogated by the legislators. So this is the first experiment. Then what happens is that in 2008, Florence enacts a new urban regulation. Now, you see it's in Italian. I know you are curious about what's coming next, but and yes. So what this urban regulation includes is a list of prohibited behaviors. You cannot wash yourself in public, you cannot urinate, and you cannot do this thing. And now we will talk a little bit about it. There is a very comprehensive list of behaviors that if of rules for as they say decor, hygiene, and peaceful living together. This is basically the idea. It looks like a list of good advices that the city is giving to you. If you violate one of these rules, you are subject to a fine from 50 to 500 euros. This is basically what happens. Now, if you look at this provision, and I'm sure that Portuguese, Italian, of course, and all of you can understand, you can see that on its face doesn't target begging directly, no? It targets this having a nuisance attitude toward the other people or causing obstruction to the pedestrian flow. And then you can see after in the provision, it says all these, at the very end on the third line, all these behaviors that are prohibited, even when begging. Anche effettuando questo. So by its own face, it looks like a neutral provision, but it can be violated even if somebody is begging. You can also see that there are a number of behaviors that are described in the provision, such as the cleaning or washing windshield or traffic lights or other parts of cars. So you can already imagine what is part of the origin of this provision. It's the experience that was made during the 2007 emergency ordinances. So this is our starting point. This provision is still valid, is still used, and it's the provision that the local police, not the state police, this is something that is directed at local police, uses to push beggars away from the city center of Florence, to clean certain areas or to maintain, as Alessandro said, a balance. So we should not understand this as a constant pressure by police that every day, every hour tries to chase beggars, but it's something, it's the instrument that is used to push beggars away. Now, on this background, I would like to address three main points. One is about discrimination, one is about the rule of law, and Alessandro already said something. The last is about access to justice. So, for discrimination, we have two levels. A discrimination can be a normative discrimination, so on its face, the law can be discriminatory. This is not law, is a secondary provision. Or it can be applied selectively, no? The first kind of discrimination is easier, of course, to target. You just you sit in your desk and you do your comparison, you do your analysis. This provision, according to our analysis, presents some elements of discrimination on its face, because you can see it's very detailed, and the kind of behavior that are described are those that are usual engaged by beggars and not by many other persons. But what is interesting, and what will be very interesting to research, is how this provision is applied. But here you encounter a great difficulty, which is the fact that the local police is not willing to disclose information about how this Article 15 letter E is used, so to release the number of fines that are issued to whom. So this is the first element. The second element that I want to address is the element of rule of law. And you have several sub-topics here that deserve to be highlighted. The first is a general element. I will not go too much into the technical details because I don't think it's interesting for a Brazilian audience. But the first question that could be raised is, does the municipality has the competence to prohibit such behavior? Does the municipality has a legal basis to enact this kind of regulations? And it's quite confused. It's a very complex issue in Italian law. But it could be said that probably it has no authority to engage in such a detailed list of allowed and prohibited behavior. And you also have to understand that in the political discourse in Italy, there is a recurring argument about the need to respect the law, principio di legalità, principle of legality, which is addressed to, usually by the political discourse, to the citizens. So the citizens should, or every individual should respect the law. But the core meaning of the principle of legality is the other way around, is the public power should respect the law in any behavior, in any conduct. So the first question could be about this principle of legality. Is this respected by the local municipalities? And once again, it's not easy to subject this kind of regulation to judicial review because of the way the Italian ordinary administrative court system is organized. It's not easy. The second element that I want to highlight is Alessandro already said something about this, the deviation of this kind of regulation from their institutional purpose. So we are talking about beggars. What does it mean to fine a beggar 50 to 500 euros? Can you collect this fine from a beggar? Of course you cannot. So the real purpose of having this provision and having this activity of giving tickets to beggars is not collecting the fine or deterring the behavior, but is to give some legal basis for the police to act. So what is interesting here is not the institutional activity, the institutional goal of the provision, but the instrumental activity by the police, which becomes the central focus in this picture. And this deviation of something from its natural goal, it's something that should red flag immediately that something is going wrong. The third thing I want to highlight is a good note. And we don't have in Italy a criminalization process like you see in other countries, for instance, in the US. In the US, where this is much studied in the context of homeless people, there are instances in which a behavior that is prohibited by a local regulation gives rise to a fine, to an order not to stay in a certain place, and if it's violated, then it could bring the person to jail time and prison. We don't have this. So we only stay at the administrative level, have this police relation with the relation between the police and the beggars. So much for the rule of law. The third thing that I want to address is the access to justice. So Alessandro already said we launched one case that was about the building of a database of beggars by the city of Florence, and we studied a case about trying to subject this behavior of the police and these tickets, this fine for violating this norm, to judicial review. And we found that we could not subject this kind of thing to judicial review under Italian legal system. For technical reasons, I will not tell you why. If you are interested, we can talk later and so on. But that's why we filed the petition to the European Court of Human Rights, which is based on two prongs, but the first prong is the denial of the right to access to a judge. And the second is discrimination, of course, because we ask then the European Court of Human Rights to enter into the field. But coming to the other action, the thing you encounter while talking about access to justice are the usual, of course. And yesterday morning we heard a very interesting panel about this. The naming, blaming, and claiming. Of course, beggars are not really keen on what their rights are, and they are not even very interested into making something about it. Maybe they don't want even to break this equilibrium that they might have on the street, at the street level with the police. No, so this is one thing. Then there are economic obstacles, but these can be overcome by social or NGOs that support the activity. But we found that there are a lot of obstacles in the proceedings. So the way Italian civil procedure is devised does not help this kind of public interest litigation. And I go to the conclusion. Two things to conclude. A self-critique, if you want. We are aware of the fact that in the Italian political arena, beggars have no support. They have no representation. This is easy, not only because they are not, often they are not Italian citizens, but because they have no power, they have no money, they are not a group also, they are not homogeneous, and so you have a lot of issues. So there is there are few associations that deal with this, but there is no wide support, wide basis in the public. So we are well aware that our approach, which I think is important, may risk to produce only symbolic victories. Even if you have a victory, which is already something that is not easy to achieve, we risk a little bit to only have a symbolic victory. Yes, we managed to have this provision declare in violation of the rule of law whatsoever, but then we produce a little change. And you, Cecilia, said a lot about this dimension, And the second element is also that when you alter a certain equilibrium, because now we have an equilibrium, it's not something, there are not concentration camps, so it's an equilibrium in the street. When you take a normative and legalistic approach also to protect beggars, you might risk backfires in a way. But what is interesting, and it's important, is that this all happens without a law at the national level. And if there were a law at the national level, even a bad law, you could then entertain a constitutional argument, a violation of constitutional argument, which is much less easy to do with this kind of secondary regulation. So with this, I thank you for your patience, and that's it. There are other provisions. I just wanted to say that it's not only Florence. I just brought other two cities. It's basically the same thing.
Okay. Thank you, Giacomo, and thank you for having me here. Thank you for the organization of this this very good conference. Now, I would like to link to this topic that we're talking about, but moving a bit to another dimension, which is the Islamic and Muslim presence of minorities, Muslim minorities in Italy. Now, of course, I will try to be short because I know we are running out of time. But I know it is necessary to give you for the Brazilian people, give a small background information on the Islamic presence in Italy, which is actually a trend topic in all over Europe because. Countries in European countries, let's say, Muslim and Islamic presence is linked to both new and past trends of migration, and to a certain extent also to modern topics like terrorism and security. Now, focusing on Italy, the Islamic community is experiencing an increase both in numbers but also in social media visibility. As also Professor Simoni was showing you the picture. It's also part of the current political debate. Now, the presence of the Islamic religion in Italy is quite recent, and it is mainly linked to the immigrant population because there is a small percentage of Muslim Italian Muslims, but it's like, let's say, it's so minimal that it's not even. I say we won't take it into account. Anyway, according to national data, the total number of foreigners of Islamic faith in Italy is almost 1.4 million, which is actually quite a big number. But the composition of the Muslim community in Italy is quite various, and in fact is actually a multi-ethnic, or as Andrea Pin defines it, it's an ethnic mosaic. In fact, differently from other European countries, for example France, where the tendency is to have an ethnicization of the immigrant population, where the majority of the Muslim population comes from, let's say, African countries, or especially North African countries, because they have a stronger historical connection with the former colonies. In Italy, the most significant Islamic communities is very various, and is composed by several, let's say, by the people coming from several countries. Of course, by North African countries, like, for example, Morocco is one of the biggest Islamic communities in Italy, but also Albanians, people from Bangladesh, from Pakistan, from Tunisia, from Senegal, Nigeria. But anyway, this variation creates versatile implementation of Islamic practices according to the country of origin and to the level of secularization of the let's say Islamic religion according to the different communities. For example, there is a very short case of Albanians, which are actually mainly also in the Tuscany region, which considering their historical path, they are considered Muslim. They consider themselves Muslims, at least the majority. But the kind of Islam that the Albanians implement is more, let's say, secular, compared to other Muslim present in Italy. Now, in general, compared to the rest of Europe, Italy's attitude towards religious minorities has been more tolerant, or at least accommodating, and this approach is perceived also in the practice of informal agreements to accommodate the religious needs of Muslims. Now, in legal terms, the legal framework regulating the relationship within the state and the Muslim communities is mainly linked to the protection of religious freedom and legal treatment of religious minorities, which, according to Article 8.3 of the Italian Constitution, establishes that religious dominations, other than the Catholic one, which is, of course, the majority and the biggest religious community, have the right to self-organize according to their statutes, and their relations with the state are regulated by law based on bilateral agreements, which are called intese. So this kind of agreements, and this article applies to all religious minorities, giving them the possibility to obtain the legal protection of religious freedom. Now, however, the presence of a fragmented Muslim community has been translated into a difficulty in reaching these bilateral agreements, this intese, and also, in regard to the Islamic community, in fact, there is no a single unique big Islamic community that can be, let's say, the main character connecting with the state or creating an agreement with the state. So this fragmentation is also evident at the legal point of view, because there is not a single agreement. There is not yet an agreement, an intesa with the Muslim communities in Italy. And in addition, when dealing with Islam, some other concerns arise. In addition to this, of course, legal area. In fact, as previously said, Islam is, especially in the last few years, at least 10-15 years, has been strongly associated to migration, and both legal and illegal migration, and security, due to the mediatic visibility of Islam, considered as a, let's say, a threat to Western values, and in this case to Italian values. It is, in fact, adding a lot of pressure on the perception of Islam, the fact that many of the migrants crossing the Mediterranean Sea from Northern African countries, or Africa in general, reaching the southern European countries, for example, Italy, are Muslim or coming from Muslim majority countries. So this factor creates an overlapping between religious identity on one side and migration issues. That are basically, very often, especially in the political discourse and propaganda, they are translated into misunderstandings, uncertainty, and confusion in regard to recognition of the rights of Muslim communities living and residing in Italy. What happens most frequently is that in the absence of specific legal agreements framework, the needs of Muslim communities are dealt with on a day-to-day basis, so on a day-to-day approach, trying to solve the single cases and the single necessities of the Muslim communities with ad hoc solutions. Now, in this sense, I would just say that local and regional authorities, once again, have a role in regarding to adjusting the relation with the Islamic communities. And for example, I wanted to talk also to say something about the city of Florence, that regional and local authorities have a competence in regard to the creation of places of worship. So in our let's say in our discourse, in our study, I will address the topic of creation of mosques, but each region can deal with it adopting different regulations. Therefore, what happens is that in every region, the legal situation can differ. can differ. And for example, in this case, in the case of the city of Florence, ad hoc agreements have been reached for the realization of a mosque in a town close to the municipality of Florence, which is the town of Sesto Fiorentino. And this agreement was reached only recently, very recently, after many attempts by the Imam of Florence, which is also the representative and the leader of one of the biggest communities of Muslims in Italy. Between the imam, the local authority, so the mayor, the archbishop, and the university. So different legal actors were included in this agreement, and this gave the possibility to create the mosque as an Islamic cultural center. Now, an attempt to redesign the legal framework on the, let's say, the construction of places of worship was made in 2009 by, let's say, there was this decreto, draft law by Zaccaria on the right of religious freedom in matter of places of worship, trying to approach the lack of national legislation on these topics. Even in last year, in 2017, another draft law was presented to address the topic of religious freedom in Italy, which is still does not present a general legal framework, which is still not directly addressed. Another case, still in the city of Florence, was the agreement reached in 2016 between the imam of the Muslim community and the mayor, which was called the Pact on the Constitution, in which the Muslim community committed in respecting the values of the Italian constitution, and on top of that, other commitments were taken by the imams, part of this Muslim community, to respect not only the Italian values present in the constitution, but also to, for example, use the language of Italian other than instead of Arabic, or both languages when addressing, for example, the Friday prayers, or also in the when reading, for example, the verses of the Quran. Now, this type of agreement could be used and is intended to be used as a replica in other cities as well, with other Italian communities. And these two cases can give us an idea on the fact that practices in a city like Florence could be perceived, they could be seen as a laboratory for good practices that could be also relevant at a national level, since there is a lack of general legal framework. However, I will be short now, I'm almost concluding. The point is that the recent Italian political developments are not evolving positively in regard to the recognition of rights of Muslim communities inside the country. And actually, the current government has developed this so-called contract of government, contratto di governo, which explicitly addresses religious minorities in the chapter of immigration, and in particular those who have not reached agreements, or those called intese with the state. Therefore, Islam is one of the main religions. And in addition, still in this contract of government, for transparency reasons, it is said that, and for the prevention of terrorism, it is foresees the creation of a register of religious ministries, so imams and other ministries, like, let's say, religious people, leaders, and the possibility to keep track of the funds used to build the mosques and other places of worship. Now, in this document, it is also envisaged the possibility to close down the places of worship, which are considered irregular. Although one funny, let's say, one fun point is that, as also the Imam of Florence was pointing out, if you do not define what is legal, because there is not, let's say, a legal definition of what can be regular or irregular, how can you close, what can you close if it's not addressed by law? So there have been attempts to redesign these legal frameworks, but let's say it's still the choice of linking Islam and religious minorities, in this case Islam, and the migration is still a solid political construction. But this goes beyond the legal recognition, because in purely legal terms, there is no basis for such a link, because actually the legal framework, and for example also the article of the Constitution, was created in a period where Islam was not part of the political, was not part of the social, of the society of Italy, and it was addressed to all religious minorities in Italy. And so the point is that this political construction, although sometimes wants to use the legal tools to have legitimacy, this is not yet possible, because there is no legal basis for such a link. And I will close for this. Thank you.
This was a lecture I gave in a conference, and I'm trying to improve the paper, and I will be glad to discuss it here again. And let's. Oh God, I'm not finding it. Okay, here. So my presentation will not be actually. I'm not use the slides. It's only to structure a little bit to make it easier for you to follow my reading. Concerns about social decision making and social ordering are ubiquitous. Important decisions about the future of society are now being taken by economic agents in the market, by indigenous communities struggling for rights in Brazilian Amazon, or by political science scholars researching or sociologists researching the sociology of law. We are all now shaping the future we're going to live in. There are nevertheless questions about the limits of economic, legal, or scientific decision-making, which are central for the common future of many, and which became a matter of political concern in the last decades. Modern politics can, as such, be described as a procedural projection of desirable forms of social ordering into the future, and at the same time, possible collisions between different conceptions of future may assume the form of a conflict that can only be decided by collective political process. What I'm saying is that actually politics is the arena where we conceive social futures, and of course there are always political clashes between different conceptions of future of social ordering. Since the 18th century, the modern organization of collective decision making has gradually assumed the form of a constitutional order that legalizes social conflicts and attempts to convert its destructive potential into a productive source of social creativity. Struggles for rights have become the stage for shaping social future, and different conceptions of order have crystallized in the great ideologies of our time. Liberals have stood for individual rights as the basis of the social order, very often disregarding the collective consequences of a pure self-interested individual decision-making. Socialists, for their side, have attempted to reveal the social conditions of individual freedom by emphasizing collective decision-making and often becoming at odds with decentralized dynamics of spontaneous and dynamic social life. Women have also organized and denounced the gender biases of social and private contracts, and of course modern politics has excluded ways of life deemed incompatible with its form of organization of politics. Societies that are at odds with the structures of social individualization and increasing specialization of knowledge are being destroyed by the expanding dynamics of the modern state and economy for a while now. Still, the constitutional political structure based on the broad inclusion of all individuals has produced valuable means for dealing with conflicting conceptions of order within its own, albeit also destructive limits. During the 20th century and within the rich industrial countries of the global north, national politics organized by constitutional processes has become a quite ritualized system for the production and negotiation of political promises. As such, increasingly bureaucratized actors were able to claim to have the best conception of the future, different conceptions of the future, trying then to conquer the support of social majorities to influence the balance of rights and thus the future of the social order, the social order of the future. On the international level, the world order, which has also happened to grow into a quite institutionalized system in the last century, has become increasingly described according to the semantics of development. As a global equivalent to the national semantics of constitutionalism, the developmental ideology has been converted into the normative standard organizing conflict and cooperation between nation states. Accordingly, some states were closer to the normative model of what is a good and developed social order, while others were still struggling to become developed. Thereby, the semantics of development returns the problem of social ordering back to the states, and the order comes to be understood basically as a world of nation states. Reflecting the crystallized ideologies of the national political system, socialist, conservative, communitarian, redistributivist, and pure market-oriented conceptions of development have also struggled, at least since the Second World War, over how to shape the social order of world society. And they have been joined in the last decades by new candidates, such as the idea of socialism with Chinese characteristics and other new developmental experiments. Modern society does not control, however, all the social process it unfolds. One of its defining features is precisely its lack of lasting guarantee for the coordination of the outcomes of its own reproduction. In the end, crisis can always emerge as a desynchronization of social normative expectations about the future and the actual unfolding of reality. And crises usually assume the form of a political crisis, demanding readaptations of expectations and conceptions of order that we have. In the last 3 decades, one of the most striking events taking place in world society has been the accelerated transnational integration of social life, followed by a fast shrinking of time and space horizons. This process has been followed by an increasing fragmentation of law and power, an increasing disentanglement of social regulation from constitutionally organized process of decision making. Certainly, the crisis of constitutional states, mainly in global north phenomenon taking place since the 70s, is not only a consequence of the processes of transnationalization. It also has its roots in the legitimatory exhaustion of the post-war neo-corporatist political arrangement, which has made possible an unprecedented politicization of the economy, followed by the relative decommodification of labor and the soaring juridification of social life. Notwithstanding, these achievements have only been possible under the strong hegemony of nation-states in the global north over the rest of the world. In the social sciences language, the consequences of this crisis have been conceptually formulated in the language of governance. Mostly since the 90s, governance, as ambiguous and contested it might be, has been originally taken from economics, migrating to national policy making through the literature of new public management. Within the field of international relations, it became a very useful description of social ordering that focuses more on its structures than on actors and their relationships. There are no governing and governed subjects in this governance language, but only governance. And I think a lot of what you said about this micromanagement of people on the streets has also to do somehow with these dynamics, this transformation of the language of politics, because you can politicize. They just try to build these very open norms, which blank norms, which can be interpreted in very different meanings. In the last 2 decades, governance has become a commonplace to denote the feeling that there was a new set of conditions that could not be grasped by the old semantics of government, organized upon the ideas of an hierarchical ruling and the distinction between government and opposition, emerging from legally proceduralized inclusive mechanisms of binding collective decision-making. Governance reflects a more modest take on the notion that society can tame the social dynamics of its differentiated domains by means of centralized organization. And it fits perfectly to a world order that has evolved towards a multiplicity of regimes responsible for the regulation of the most different sectors of social life, and only partially subject to the direct command of inclusive hierarchical political structures based on statehood. The concept of governance hopes to transfer the explicit collision of conceptions of possible social orders of the future to the realm of knowledge-based decision-making, where cognitive cooperation becomes the central aim. Global governance or national governance become to be described as a polycentric structure of different regimes, each of them increasingly specialized in one specific issue. In the core of these regimes, there are more or less organized sectors based on different levels of legalization and institutionalization that might be very soft, very informal, and that might or not have the significant presence of states. On the side of its spontaneous social dynamics, these regimes are comprised of different stakeholders, which might count as pseudo civil societies, often working as sources for quests for legitimacy and stages for contestation. The high specialization of these arrangements remains a constant that directly favors the prevalence of an expert-based production of regulatory knowledge. The science of governance is closely related to the science of management, as shown by the profuse literature on governance by indicators, rankings, standards, and other forms of soft regulation. For sure, this brief description has many limits. First, governance structures serve very often only to mask the influence of hegemonic powers or big business. Second, empirical research has shown with convincing evidence that transnational governance may also become the object of contestation from below, from within and from without. And even experts may assume political stands, struggling for better or more democratic governance and inclusive governance from inside the governance machine. However, the quality of governance and its legitimacy problems are not the concern here. The crucial problem is, how do we conceive of an world order in a highly fragmented and politically excludent constitutional structure? As I pointed out, the locus of contestation over the building of the world order has been the idea of development, at least since the Second World War, when it replaced previous racist or colonialist conceptions. There were many ideas about how to foster development. As I already argued, the semantics of development remains, however, connected to the project of constitutionalization of politics, which is inclusive and based in the relationship between law and the political system, since it redirects the problem of social ordering back to the nation states, the development ideology. Moreover, the world order becomes only a matter of how states in different stages of development cooperate and interact. Apparently, governance gradually strips old conceptions of ordering of their validity claims, posing new challenges for the existing political systems and leading to a critical gap between political expectations and real process of regulation on the ground, on the municipal and on the global level. In what follows, I would like to propose some tentative hypotheses, that's very short to the end, hypothesis for how the world order may be conceived under these conditions of constitutional disorder. The constitutional structures of this nation state remain the most important buffer for the reactions of the public to social disruption and crisis. But what if the political system becomes overloaded with demands with which it cannot cope? The only remaining way of dealing with the perception of permanent failure might be a reactive sort of politics, and instead of assuming the form of constituting process of conceiving, negotiating, and struggling for possible social futures, the political system may become a national collective outcry directed at an evolving social global ordering that it cannot control. The world order, for its side, would become a space for waves of disruption coming from nation states that would endanger the mechanisms of societal coordination. Instability and political backlashes for global and transnational regimes of regulation could become the new normal. The second hypothesis is the lack of process that can be perceived as meaningful and inclusive and legitimate constituting mechanisms of binding collective decision making can also make room for a highly destructive form of political struggle. The feeling that there is no more common ground where different perspectives of social ordering can mediate their differences may enforce the friend-foe distinction as the fundamental political distinction in a very explosive way. By that, I mean the revival of fundamentalist and all-encompassing ideologies. The world order might become a destructive stage of conflicting forms of nationalist fundamentalisms, be it the market fundamentalism, national fundamentalism, religious fundamentalisms, or other forms of ideology. In the long run, and that's the third hypothesis, frustration can also be translated into cognitive social learning. Indeed, modern politics might have been no more than a sterile illusion of collective omnipotence. As the evolution of of a transnationalized society advances, social conflict can be gradually replaced by spectrocratic contestation and within fragmented polycentric governance, and further social order, world social ordering can become the exclusive result of incremental cognitive learning made by knowledgeable social engineers. Social asymmetries, social exclusion, inequalities can be deemed the result of nature features of social life, or just the exclusive consequence of individual failure. Instead of struggles over the future, acceptance. Instead of social critique and political intervention, resignation. That's a very that's a provocation. This paper much more than the result of research. I presented other papers in this conference which were more like the result of my current research. But I think since the topic was social inclusion and exclusion, I thought it would be useful to try to make sense of this big picture. Well, that's it. Thank you. Yes.
Thank you very much. I just want to make a short question to Giacomo. Yes. Your presentation was really interesting, but I was just curious with the label you used, the beggar or the beggars. How did you get to this label? Because you were so focused on the activity of begging, and you were focusing on this mayor ordinance. In begging, it's a worldwide phenomenon. I'm not sure how it works in Italy, but if you take, for instance, the example of United States, and there was a report that was made by the Human Rights International Clinic, so Carl Lovenstein from Yale, and they came more or less to the same research you were doing. And the problem was not only begging, but also panhandling, loitering, sitting on benches. And the title of the report is quite interesting, Forced into Breaking the Law, the criminalization of the homelessness. The problem was not the begging for itself, it was the increase, the number that was increasing of homelessness in Connecticut. So my question is it the same? Is not the same case there in Italy? Is homeless a problem there, or is it another type of problem, or is just the begging by itself?
No, this is surely a terminological issue, partly
because Cecilia was proposing that we pick
sorry.
more.
Yes.
Because we don't have a lot of time.
Yeah.
So, first of all, thank you for the lecture, and my question is also for you, Jacob. And on the other hand, about this specifically case of Florence, do you have any public policy to give shelter to those beggars? And it's just exclusion, or there is any kind of public policy to give them shelter?
There is an interesting collision between the first discussion and the case study that you've presented that I would like to just, I don't think we have time, but just point out, and then we'll see if we have the possibility of discussing it. You, Cecilia, you rightly pointed out that NGOs and activists and even litigation with subalternate or vulnerable people can, and you made the example of Quilombo or of indigenous people in Latin America. This action can make invisible the practices of these people and this community. And actually, as Alessandro was pointing out, and also Giacomo was referring to the fact of using the law as an instrument, as a tool for implementing rights of people, but using it without making reference, for example, in the case you have presented, without making reference to the ethnicity, or I'm not quite, I don't know, because I haven't read your application, but this was clear. We're using the law without applying, without implying or employing the specificity, which actually was very interesting, and it makes all the discussion, the sociological discussion about this issue very relevant. Well, in my opinion, if you take, for example, the case law of the Inter-American Court of Human Rights specifically on the right of indigenous population and indigenous community, what we can draw from that, which is not the same experience that the European Court of Human Rights, for example, has, and for obvious reason, historical and so on, is that they may, when they did succeed in actually declare a violation of rights of community and indigenous rights, they actually made these practices, and I don't know, obviously then the problem of identity, self-representation, and also epistemology and self-epistemology is rightly pointed out, and is probably still there. But the court says something, and if we take it from a legal reasoning, for example, perspective, the court is saying, the Inter-American Court is saying that those practices, that in some cases, it actually analyzes quite in depth, with an in-depth analysis, these very same practices are relevant from a legal point of view. So it succeeded in make those practices, which we sometimes we consider them from an ethnographic point of view, so we consider them as non-legal. It actually succeeded in make them relevant, legal, and actually the basis on which then they actually find a violation. So, and I finish that. But here I think that your presentation, and Giacomo actually was aware of that, and you stressed this point. But here we have probably one major issue concerning the right of how to protect, how to do litigation which is strategic, and we can achieve something, as you were rightly saying. And I don't think we should avoid to think and to refer to those practices. And thank you for your speech. And I'm sorry it's not a real question because you can not open a discussion on that.
Well, my question will try to reach everybody on the table. So, first, I thought it as this kind of colonized settler condition, which means that the colonization now is affecting those who colonized it before. So everybody's feeling like we were being colonized by those who we colonized before. That's what some kind of, I don't know, maybe in this way the dominant legal the dominant law of a space, of a state of exception, if you want, where the law of the other can exist as long as it is compassed as the dominant culture. So the question is, can the law really be a feature of defeating this state of exception for those who are in this condition of migrants or in another country? I mean, because law is not for them; they're not citizens at all. I guess maybe I don't know what to do about it. But in the second part of this question, maybe more for Cecilia, is that one of the chief trends that criticize human rights is the view that human rights has first a kind of anthropological scene, that it is to say that it is its relation to colonialism. So, in the perspective of epistemologists of self, the second question to Cecilia would be that in what extent can human rights, I mean, this human, white, a man, a male, human rights can be a feature for struggle colonialism?
So I go very quick. I think we are 30 minutes behind schedule, but so thank you very much for the questions. So beggars, yes, it is a little bit a terminological problem. Also, language mediated by language. Let's say more street level economic activities in the first place. This is the target. But there is maybe a difference with the U.S. Where in the U.S. it usually the researchers are mainly around the homeless people, and while in our case it is more beggars or panhandlers that are identified in these two groups. It used to be Roma and now Roma and migrants, if it makes sense.
I would maybe put it relatively in this way. The point is not that they are beggars. The point is that the authorities choose begging as a legal framework in which they deal with them. The point is that certain groups are visually unacceptable for the population. Okay, so the point is to make pressure on them. You can choose the begging framework. You could choose in the past the vagrancy framework. You can choose illegal small. But the game is the same, even if the legal framework changes. So you can call them beggar, you call them vagrant, you can call it panhandler, illegal merchants. That's not the point.
Yeah, but that was not my question. My question was, what is the target of this type of crimes? Because if you met them, who is being criminalized by them? It's not that I'm at home, no, today I'm going begging on the streets, no? Or I'm just going to be a vagrant or loitering by itself. But who is the group of population? Is it a certain specific group? And that's what I mean.
No, this is not the sense. The person that we defend are beggars only in a specific. They could be something else if, let's say, the economic advantage of other activities, legal or illegal, becomes more than begging. So it's so they are not. And the point is that in Italy there is a tradition of labeling some group as culturally prone to begging. So specifically Roma are targeted as they beg because it's part of their culture. But the reality is much more based on economic, let's say, factors. I mean, some groups can choose begging since it's profitable, and maybe in the following month they make completely different activities. So it's there is no substance indeed in the category of begging. What decides are these persons normally are, in terms even of clothing, for instance, they correspond to certain stereotypes, which makes them target for the application of anti-begging rules. Even paradoxically, you can find other groups beside who beg more intensively than them, and they are not targeted by any kind of police activity. That's, you for instance, you can say, let's call that the panca bestia or so it's, the point is not they are beggars, the point that they are or Roma or now they are black. Because the point is, you don't, like in the US, like the rules on, say, you targeting the fact of...
and the goal is, appears to be cleaning, now presenting a different public dimension. So, this, then, shelter inclusion, you mean it's all bad? There is, if I understood correctly, is there any other face
not
of
only
the
exclusion policy?
Yes, it's so interesting because I come from a very different perspective, and it's interesting to see that a sociologist or a person that studies sociology goes into these other elements. Yes, I would say this is only anecdotal relating to Florence, but the others are better qualified. Yes, there are social inclusion instances, even within the municipality, in housing and stuff like that. So yes, there are. Then, Sophia, thank you very much for your also presenting another side of the story. And we decided to not make reference to the ethnicity. It was a strategy decision, no? So we wanted to go straight to the violation of the legal division. So this was, let's say, a lawyer call, but also maybe reflects the artisanal approach that we have in a certain way. And briefly coming to your remark, citizens, not citizen, it's important, probably especially in the democratic process, know who is represented or not represented. And certainly the law tends to be more against than in favor of certain groups. But I'm not entirely sure whether it's still, even if you're not citizens, I mean, you have rights under the law. I don't know if I got your point.
One more, under the permanent state of perception of this city, the Homo sapien perspective of I mean, the law for them is
yeah, they are a target only. Yes.
They are a target of the criminal law. That's the way they see law, maybe. That's the point of the access to justice, maybe the access to the justice for criminalize them. That's the key I'm trying to help you figure out this kind of citizenship, because we can also discuss it as biological citizenship, because they have some kind of ethnicity as well to engage with the point we were discussing before. So they have their genetic condition, let's just say they're colored, you said they are colored, and the other elements that they represent don't give them this state of citizenship.
Thank you for the provocation.
There is a kind of Petrina Petrina, which is a Russian anthropologist. She works with this category of biological citizenship, so maybe it can be something interesting for this case.
Thank you.
In 1 second, yes. Thank you for the comments and the question. And I think it's interesting that you are doing this amazing work, for the human rights of the immigrants, and both citizens and non-citizens. And it does relate very well to the critique of the liberal approach to human rights. But from the perspective of the epistemologists of the South, and also in my view, this does not mean that we should not be using law, even if it's contradictory, if it's excluding, always including, excluding. And so what I think it's interesting here in the lessons I take from this kind of perspective that I presented is this self-awareness, the self-reflexivity of our own privileged positions. As scholars, as lawyers, we have the privilege of speaking for. So when is speaking for contributing to exclusion of some things, there is always exclusion, inclusion in representation. If we start to also think about our role in promoting those exclusions, that what I see as an important lesson. But the lesson also of being critical of the law itself. And so this is a role of scholars and activists together, in my view. But listening to what the groups we are representing, what they want and how they represent themselves, how they construct their own subjectivities in relationship with the law too. So I think that is another important task that it's not often taken seriously by legal advocates. So that's why, in my view, your comments are perfect. And so this responds to the last question. Yes, we can use the law. Yeah, the Inter-American Court of the Court of Human Rights, the Inter-American Court, has made very important decisions and very much ahead of the nation states. But there are limits too, and that's again a political institution. It's an interstate organization. It's very complex. So again, if we only concentrate on law and legal mobilization from a legalistic perspective, yes, there will be some gains, but then also limitations. So it all depends on where you want to fight, I think. Thank you.
I think it would, I can address your. I mean, I was only one who. I think. I don't know that if we are watching recolonization in inverse colonization. I don't think is that. I think we have really a problem of a constitutional problem. We are living in a constitutional crisis in Europe, also in Brazil, and this reactionary politics is a consequence of that, and it has to do with how modernity shaped politics and the changes modern politics is going through in the last decades. And I see a connection. I mean, of course, my paper was a little bit abstract, but I see a clear connection between what I'm talking about and this kind of management of bodies in the streets of Italy. I mean, it's very clear that these people they don't belong to the political system. They don't count as persons for the legal system, and so these blank kinds of these blank norms that are applied in administrative, often very illegal and unconstitutional ways, they have to do with the fact that they don't count as members of the political community, but actually, if it's not scandalized, it cannot be scandalized because the political constitution is changing. In Europe is a very strange thing for me because, of course, the whole constitutional European project is a very problematic thing, and they are discussing a lot about that now.
It's also